Thank you, Jan. As Jan mentioned, my husband and I were Christian Scientists. We were devout, lifelong Christian Scientists. In 1977, we lost our only son, Matthew, to a very treatable illness because of following the church's beliefs against medical care. We left the church right after his death and have devoted the rest of our lives to enhancing the rights of children to medical care. And we have founded this national membership organization, Children's Healthcare is a Legal Duty, and there are flyers on the table outside. And I do have a short memoir that I wrote about the loss of our son, which is also available for sale. I'm going to spend maybe 10 minutes talking about the beliefs of religions that object to medical care, and they will be those. These faith healings, or the faith healing sects, believe that God can heal all diseases and injuries without the use of drugs or other material remedies, and that reliance on a physician dishonors God and causes spiritual or physical penalties. The most prestigious of these sects is the Christian Science Church, which has almost single-handedly gotten hundreds of religious exemptions into state and federal law. Most of the other sects that are opposed to medical care in general are charismatic and Pentecostal, and many of these Pentecostals believe that the crucifixion of Jesus redeemed man from sickness as well as sin. Like the Christian Scientists, they see the cause of disease as a temptation from a supernatural evil force that takes hold because of the individual's moral shortcomings. And since they do not believe that disease is caused by bacteria, viruses, or insulin deficiency, they do not regard the physician as a helper or a healer. They have other remedies that they rely on for healing disease. Many Pentecostals emphasize the importance of forgiveness, that the sick person must forgive his enemies, he must give up resentment. Christian Scientists believe that all disease is caused by ignorance, fear, or sin of the patient, or in the case of a young patient, of the parents. And so the remedy for all disease in the Christian Science faith is a type of prayer that they call treatment, which involves convincing yourself that disease is unreal because God did not make it. God is good, God is the only power, and you are a perfect spiritual image of God, and you don't even live in a material body. For both groups, prayer becomes a strident, legalistic argument. The Pentecostals, quote, plead the blood of Jesus. They argue that the blood of Jesus has redeemed them or their loved one from disease 2,000 years ago, and therefore Satan has no power over them. They often are arguing with Satan. By far the largest denomination with objections to medical care is the Jehovah's Witnesses, with millions of members. They oppose blood transfusions, and they cite verses in both the Old and New Testaments that prohibit eating, quote, meat that has its lifeblood still in it, and verses commanding persons to abstain from blood. They believe that the soul is in the blood, and that Jesus Christ presented a perfect atonement for the sins of all mankind by shedding his blood. And therefore, accepting a blood transfusion tramples on the Son of God, the Witness publishing house has said. And for several decades, the Witness hierarchy also said that blood transfusions involve cannibalism because they said the body eats the blood. Well, you can understand that if a faith community believes that, if a Christian community believes that a blood transfusion is trampling on Jesus Christ himself and involves cannibalism, that they would have very strong moral objections to blood transfusions. As they have evolved to being a sect with millions of members, they have had to make some exceptions to their policy. And while they still prohibit transfusions of whole blood and major components of blood and auto transfusions. The reason they prohibit auto transfusions is that there's a verse in the Bible that says that blood has to be thrown out, it has to be disposed of, and so they don't want it stored for later transfusion. They prohibit all of those procedures involving blood, but they do also allow several other forms of transfusions today, which I could explain. The Jehovah's Witnesses are not faith healers. They do not claim that God will heal them without transfusions. In several of their publications, they embrace martyrdom and praise those who go to their death rather than accepting transfusions. In others, they use statements from medical journals to show that transfusions are overused and that blood substitutes will work just as well as blood products. I'd like to talk about the medical beliefs of the Church of Scientology. They oppose some forms of medical care, mixing their beliefs with the science fiction written by their founder, L. Ron Hubbard. Scientology attacks the mental health profession vitriolically, in particular. And in my view, the reason is they're in competition with them. Well, they've got their own mental health system, you know. They claim to be able to heal all mental health problems by Dianetics, performed in expensive sessions with galvanometers and accusations in front of the group. They also believe that babies should have a silent birth and not be exposed to any discomfort or language for at least the first week of life. If you can imagine not saying a word to a newborn baby for a week or 10 days. They believe that words or discomfort will be recorded by the baby's reptilian brain. And later, years later perhaps, when this person experiences the same sensory data or the same words that were said to this baby, his reptilian brain will kick in and reenact the newborn's birth trauma, and it'll just be very traumatic for this person. Hubbard claims that total silence during birth is necessary to save the, quote, sanity of the mother and the baby. On that basis, Scientologists refuse to have metabolic testing, immunizations, or any other injections of babies until they are at least a week old. Also, their dietary beliefs have endangered babies. Hubbard discourages breastfeeding because there are few, quote, Guernsey-type mothers today. And recommends that infants be fed barley water instead. And he claims that he called up the formula for barley water from a deep past, 2,200 years ago, when the Roman armies marched on barley. There are several other churches who have lost children because of medical neglect, and yet we don't see their written theology against medical care. And these include 12 Tribes and the Church of Wells here in Texas and the Amish. And one reason these harms occur is that the decision for medical care is often made communally. It's not just up to the parents, it's the whole community involved or the leaders of the group. And oftentimes these groups do not have health insurance. Most prominent of these groups are the Amish, who not only lack health insurance, but have strong religious beliefs against accepting public assistance. The Amish maintain separation from the world through group solidarity and caring for their own. The whole community is expected to help pay expenses when members need financial help. They have low rates of immunization and other preventive measures, which to them show a lack of trust in God's plan for their lives. Many of their babies are born at home, attended by church midwives without state licensure. And they regard education beyond 8th grade as a threat to their way of life. They place a high value on the work that everyone is expected to do to make the community function, And they tend to regard illness in terms of whether or not you can perform in your work role rather than of your symptoms per se. They also want to live in a pre-industrial culture and often make use of folk remedies and quackery from the 19th century. While their community spirit and tradition of caring for members are admirable, they also cause reluctance to burden the community with high medical costs. And Amish babies have died simply because the medical care was too expensive and the community just felt that they couldn't pay for it. The parents didn't want them to pay for it. In one case, and this was the baby survived, but the medical bills were over $600,000 when an Amish baby contracted tetanus. And the community didn't have that kind of money to pay the hospital, and the Amish absolutely would not apply for Medicaid or any form of public assistance. And so the hospital ultimately had to settle for 10 cents on the dollar. I'd like to talk now about Christian Science beliefs, just to, since I know the most about it, just to kind of give you a feel for what the environment around a Christian Scientist would be in a healthcare situation. The church and many of these other faith-healing churches will always say, well, we give the parents freedom of choice. But when you look at the doctrines in place, the messages that these parents are getting, it's a lot of pressure, even though technically they have freedom of choice. In the first place, there's no way you can get information about the disease without violating the theology. Mary Baker Eddy, the founder of Christian Science, says that a physical diagnosis of disease tends to induce disease. So you have no rational information to make a decision about what to do. The religion sets up spirit and matter as opposites and antithetical. God is spirit, then modes of healing other than the spiritual and divine break the first commandment, thou shalt have no other gods before me. Well, that's a pretty serious prohibition. We cannot obey both physiology and spirit, for one absolutely destroys the other, and one or the other must be supreme in the affections. It is impossible to work from two standpoints. They believe that doctors cause disease rather than cure it. Mary Baker Eddy says the hosts of Aesculapius, those are doctors, are flooding the world with diseases because they are ignorant that the human mind and body are myths. And faith in rules of health or in drugs just simply begets and fosters disease. Mary Baker Eddy says the less we know or think about hygiene, the less we are predisposed to sickness. She says, because God is supreme and omnipotent, materia medica, hygiene, and animal magnetism are impotent. And their only, that's a grammar error, and their only supposed efficacy is in apparently deluding reason, denying revelation, and dethroning deity. So, you know, doctors and hygiene and this animal magnetism, which is the Christian Science word for evil, they try to dethrone God. She says, it is not wise to take a halting and halfway position or to expect to work equally with spirit and matter, truth and error. And the Christian Science Board of Directors says, the patient who tries simultaneously to rely on Christian Science and materia medica actually relies on neither and is virtually without treatment, for one method counteracts the other. And to this day, that is a very strong rule of the church, that you cannot have both Christian Science treatment and medical treatment simultaneously, except if you happen to go for a very small number of specific exceptions that Mary Baker Eddy found convenient for herself. So, you know, the average Christian Scientist knows that there's no way God can follow him through the doors of that hospital. There's no way God can follow him to the doctor's office. You are just abandoned by your church if you go to a doctor. And it's a terrifying thing to somebody that has lived in that religion all their lives. This is from a court case involving the death of a Christian Science child. It was a brief filed. It says, Christian Science provides that no person may become a member of the church unless he or she is prepared to rely completely on spiritual healing as practiced in Christian Science. Members of the church believe that attempts to use medical means as an adjunct to or in combination with spiritual means destroy a Christian Scientist's power to heal through prayer. Thus, spiritual healing is the sine qua non of Christian Science and a religious imperative for members of the church. And the way to get a Christian Science healing is to deny the existence of matter, and then you can destroy the belief in material conditions. She says, the sick, through their beliefs, have induced their own diseased conditions. The sick are the cause of their problems, but you command the situation if you understand that mortal existence is a state of self-deception and not the truth of being. Another thing that I think many outsiders don't realize is that these people, followers of Christ, Church of the Firstborn, and Christian Scientists, are going to see healings. The body has a rich array of processes for healing itself. The human race did survive before there were doctors, and there are a lot of things that they will see healings from. And those healings are precious to them. They believe if they've seen one healing, well, God is on their side, that's the way God works, and they are very inclined, very dependent on this method to trust in it in the future. I want to ask, just raise the question of why should the state prosecute parents who are motivated by their faith in what they do, they love their child, and believe they are acting in the child's best interest. And of course, it is preferable if Child Protection Services can come in and prevent the harm to the child through a court order, rather than prosecuting the parents after the child has died or suffered permanent harm. But the criminal law is also very necessary in case CPS intervention does not happen. It is the criminal law that imposes the duty on parents to provide necessities of life for their child. If the parents had no duty to care for the child and we wanted to protect children through social services oversight alone, the state would have to maintain a list of all the people in the jurisdiction who believed in faith healing and send social workers out every day to check on their welfare. And that, of course, is unconstitutional and way too intrusive on the part of the state. The ability to prosecute is necessary because that's the way we establish a duty in law. You have to have a penalty in the law in order to require a certain duty. There are few of us that would put money in the parking meter if there weren't the chance of a fine. And of course, the criminal law should have a range of penalties. And the most serious penalties should be for those who commit crimes with malicious intent. But because children are helpless, we also have to penalize conduct perhaps done with the best of intentions. Many states, however, do have religious exemptions or religious defenses to crimes of injury to children. They often have Christian Science code words in them, and we've been told in many states that Christian Science lobbying is responsible for their being enacted. Many were enacted between 1975 and 1983 when the federal government coerced states through the power of funding to enact religious exemptions to child neglect in the civil code. Many of these exemptions in the criminal code came in at the same time. Today there are 17 states that have religious exemptions to felonies and 15 that have religious exemptions to misdemeanors. That is not as bad as it sounds because over the years and with our work, several states have watered down these exemptions so that they really protect only a parent's right to pray and not really a carte blanche to deprive your child of medical care in all situations. And it isn't necessary, of course, to have a statute to protect your right to pray. We have a First Amendment to the Constitution that already does that. But one example of a rather harmless type of religious defense is in Rhode Island. Rhode Island did have a terrible law with a religious defense to manslaughter, negligent homicide, cruelty to children, and child neglect. And in 2004, we presented a bill to repeal that religious exemption in the criminal code. And we could not persuade the legislature to outright repeal it, but they changed it to this following, saying, a parent or guardian practicing his or her religious beliefs which differ from general community standards who does not provide specified medical treatment for a child shall not for that reason be considered an abusive or negligent parent or guardian, provided the provisions of this section shall not exempt a parent or guardian from having committed the offense of cruelty or neglect if the child is harmed, by the general definition of harm. So that's a lot of verbiage. It's not very good English, but what it means is Rhode Islanders can rely exclusively on prayer to heal a child unless the child is harmed by lack of medical care. In several other states, the meaning of the religious defense is ambiguous, and prosecutions involving religion-based medical neglect have been in litigation for over a decade as courts wrestle with the meaning of that statute. Here, for example, is 7-year-old Amy Hermanson, who died of untreated diabetes. Her parents were Christian Scientists and affluent professionals in Sarasota, Florida. Because of a religious exemption, the judge made it virtually impossible to get a conviction. He told the jury that the prosecutor would have to prove that the Christian Scientists had not been practicing their religion when they withheld medical care from their daughter. So the prosecutor had to go before the jury and try to prove that he knew more about Christian Science than the parents did, which was really impossible, but the jury was so disgusted that they convicted the parents anyway. The Court of Appeals unanimously upheld the conviction, but the Florida Supreme Court unanimously overturned it, saying, the statutes result in a denial of due process because they fail to give parents notice of the point at which their reliance on spiritual treatment loses statutory approval and becomes culpably negligent. The statutes have created a trap that the legislature should address. That ruling came down in 1992. The legislature still has not addressed it. It's still on the books. And we have worked for its repeal in Florida. We've gotten promises from some legislators to sponsor bills, but they never follow through. But due process and fair notice are very important constitutional rights for these parents. And when you have laws that are confusing and contradictory between different chapters of the criminal code and the civil code, there are several courts that have ruled that they're going to rule in favor of the defendant, that confusion in the law is a basis for acquitting the defendant or saying that the charges cannot proceed. The death of this little girl was in litigation for over 12 years because of the religious exemption in California. Shauntay Walker is her name. This 4-year-old child was homesick from nursery school for 17 days, but the school staff did not report the case to Child Protection Services. I suspect they knew she was a Christian Scientist. She probably had an immunization exemption on file in nursery school. But the school staff did not report it. And her aunt, at the end of these 17 days, her aunt observed that the little girl was comatose and threatened to call the police. So the mother moved the child to the home of a Christian Scientist where she died. And this little girl, 4-year-old girl, weighed only 29 pounds at her death. Her mother was charged with manslaughter and felony child endangerment. And she, of course, raised California's religious defense to non-support in the case as a defense to her conduct. The California Supreme Court, unlike the Florida Supreme Court, ruled against the mother and held that the exemption to the misdemeanor did not carry over to be an exemption to manslaughter and felony child endangerment. The U.S. Supreme Court declined to review the ruling. But then, however, Mrs. Walker applied for a writ of habeas corpus challenging her conviction in a federal district court. And this court overturned her conviction on grounds that it violated her right to due process under the 14th Amendment. So these religious exemptions cause enormous complications and injustices and expenses for the state. The criminal code achieves its power through deterrence, but if the laws are inconsistent and contradictory, then they aren't sending a clear message that deters bad behavior. This is Texas's religious defense to criminal charge of injury of a child. It is an affirmative defense to prosecution under this section that the act or omission was based on treatment in accordance with the tenets and practices of a recognized religious method of healing with a generally accepted record of efficacy. An affirmative defense is one that the defendant has the burden of proving rather than the prosecution having a burden to disprove. So if the Texas parent is charged for neglecting to provide medical care for a sick child, the parent must prove in court that he provided treatment by a recognized religious method of healing with a generally accepted record of efficacy. What in the world does that mean? Who has recognized the religious method? And did they recognize it as a legal substitute for medical care of sick children? Is there a religious method with a good record of healing children of meningitis and type 1 diabetes and polio? And has society generally accepted that some churches' prayers and rituals are acceptable as a legal substitute for medical care of children because they have a generally accepted record of effectiveness? This was, of course, the product of the Christian Science Church, and based on what Christian Science parents have argued in other court cases, I submit that the evidence they would produce in Texas would be some of these things. They would say, well, Medicare and Medicaid will reimburse for our Christian Science nurses who are unlicensed and have no medical training. Secondly, they might say some insurance plans will reimburse the bills that Christian Science practitioners send for their prayers, and they do charge for these prayers called treatments. Thirdly, that the Internal Revenue Service allows the bills for these prayers to be deducted as a medical care expense off your income tax. Also, that health insurance for Texas state employees includes reimbursement for the bills that Christian Science practitioners send for their prayers. So here in Texas, you have public money going to pay for these prayers. And of course, they would tell you that the church has published thousands of anecdotal reports of physical healings from their prayer treatments. The reimbursements and the tax deductibility that the Christian Science Church has won are just amazing, but they do not add up to a societal consensus that it's appropriate to provide only Christian Science treatment for a diabetic child or a child with pneumonia or bacterial meningitis, etc. So nobody might be able to use this Texas religious defense in court, but it is still a dangerous law to have on the books. It can be used by exploitive church officials to persuade members to pay for prayers and rituals and to rely on them when their children are sick. No court has ruled on what the Texas religious defense means because, to our knowledge, criminal charges have never been filed in Texas against parents with religious objections to medical care, never in the whole history of this state. And it could be that this strange law in Texas has discouraged public officials from investigating such cases or charging them. Some states have laws that are worse than Texas's. This is the state of Washington. This is a religious defense to criminal mistreatment of children and dependent adults. It is the intent of the legislature that a person who in good faith is furnished Christian Science treatment by a duly accredited Christian Science practitioner in lieu of medical care is not considered deprived of medically necessary health care or abandoned. The legislature in the state of Washington has decreed that Christian Science prayer treatments are medically necessary health care for sick children. Last year, there was a trial involving the death of this boy, Zachary Sweezy, in the state of Washington. Church of the Firstborn parents were indicted for not getting medical care for him when he died from a ruptured appendix. And the parents tried to raise the religious exemption for the Christian Scientists as their defense. Their lawyers wrote, "The discrimination in Washington law between two religions has the constitutionally prohibited effect of providing favoritism and immunity for members of the Christian Science Church over members of the Church of the Firstborn for identical conduct." Good point. But the judge ruled against them, and based on false and what I consider misleading information, held that the legislature had a rational basis for giving this exemption only to Christian Scientists and not to the Church of the Firstborn. Yeah, right. So then the parents pled to a lesser charge. They were put on probation. Their attorney said the law was bizarre and needed to be revisited by the legislature, but his clients would not appeal. Here is West Virginia's religious defense to the crime of child neglect resulting in death. No child who in lieu of medical treatment was under treatment solely by spiritual means through prayer in accordance with a recognized method of religious healing with a reasonable proven method of success shall for that reason alone be considered to have been neglected within the provisions here. And a method of religious healing shall be presumed to be a recognized method of religious healing if fees and expenses incurred with such treatment are permitted to be deducted from taxable income as medical expenses by the IRS. And that's a defense for the crime of letting a child die by failure to provide medical care. I know a lot of people complain that the IRS has too much power, but in West Virginia, the IRS determines that some people have the right to let their kids die of medical neglect. I'd like to discuss our work in Oregon to repeal Oregon's religious exemptions. That's something that's extremely meaningful to us. By 1997, Oregon had the most awful religious exemptions in the country. It had a religious defense to homicide by abuse or neglect, manslaughter, criminal mistreatment, criminal non-support, neglect, and failure to provide. And this was, wrong direction, I had it upside down here. Oregon's homicide laws included the crime of causing the death of a child by abuse and neglect or maltreatment recklessly under circumstances manifesting extreme indifference to the value of human life, but provided immunity from those charges to those who gave care or treatment solely by spiritual means. So, in Oregon, parents could act recklessly with extreme indifference to human life, cause a child's death by failure to provide food, clothing, shelter, or medical care, but would be exempt from charges of homicide by abuse or neglect and manslaughter if they also provided prayer, certain kinds of prayer. Its non-support law said, in a prosecution for failure to provide necessary and proper medical attention, it is a defense that the medical attention was provided by treatment by prayer through spiritual means alone, by people who belong to a bona fide religious denomination, not one of those queer ones, you know. You know? So, as in Washington State today, Oregon had a law calling prayer medical care. They could provide the medical attention by treatment by prayer. In January 1998, I addressed a child maltreatment conference in San Diego. I discussed Oregon's atrocious laws. A new Oregon District Attorney, Terry Gustafson, came running up afterwards. She said she had known of several deaths of followers of Christ children in her county, and now that she was the district attorney, she wanted to file charges. A few weeks later, she got her chance. 11-year-old Bo Phillips died of diabetes, the third follower's child to die of a treatable condition in 7 months. Terry Gustafson researched the laws, including a religious defense to manslaughter that had just been passed the previous year, and decided she could not file charges. But she and the state medical examiner did alert the press, and KATU went out to the cemetery, then the Oregonian newspaper, and they found 78 graves of children out there. Later that year, a man named Bruce Starr was running for his first term in the Oregon House. He knocked on the door of a child member, and the child member told Starr about the medical neglect he had experienced growing up in a Christian Science family, and asked him to sponsor a bill to repeal the religious exemptions. Starr agreed to do so, and he later won the election and promptly introduced a bill to repeal the 9 Oregon religious exemption laws pertaining to medical care of sick children. It was a torturous 7-month battle. Christian Science lobbying had gotten those laws on the books, and the church fought tooth and nail to keep them. And when legislators see 2 groups of people strongly committed on opposite sides of a bill, their first instinct is to compromise. And so we had this bill with 9 parts to it, 9 different laws we wanted repealed. And during that 7 months, there were 75 amendments proposed to that bill. Every legislator had a different idea about what to do with it. Some wanted 3 religious exemptions repealed, another group wanted 3 different ones repealed. And many of them were trying to accommodate the Christian Science church, because the church would come and they'd sound reasonable, and these people are well dressed, they speak good English, they're teachers, they surely are not asking for a religious right to murder their kids. I made 4 trips to Oregon that year, 1999, to testify and work for the bill, and in the end, the legislature repealed 5 of the 9 religious exemptions that we wanted repealed. We hoped that would be enough to change the followers of Christ's behavior, and for many years it seemed that it had. The followers had no more deaths of born children due to medical neglect for many years. In 2008 and 2009, however, 3 followers' children died without medical care, and in 2010, a 4th was permanently harmed by medical neglect. And also the Oregonian that year wrote columns complaining about Oregon's laws, that there was still unequal protection. And so we began to think, well, maybe if the Oregon House was absolutely evenly divided between the parties, and in the Senate the Democrats had only a 2-vote majority. But the pundits were so wrong, and really the legislature set a model for the nation and for Congress. In the House, our bill passed unanimously. There were only 5 votes against it in the Senate. Oregon has gone from having the worst laws in the nation to being one of 6 states with absolutely no religious exemptions pertaining to medical care of sick children. And no followers of Christ children have died in Oregon since 2009. But as Linda told you, some of the Oregonian followers of Christ have moved to Idaho. And again, because of Christian Science lobbying, Idaho has a religious defense to any crimes that could possibly be charged in a neglect situation. And none of the many deaths of Idaho followers of Christ have been prosecuted. The prosecutor in Canyon County has publicly said that parents have a legal right in Idaho to withhold life-saving medical care from children, So the coroner in Canyon County does not even do autopsies on the children because the law requires autopsies only when a crime is suspected. And so even after our success in Oregon, Idaho and at least 4 other states still have a religious defense to manslaughter or negligent homicide. Nearly 70 years ago, the U.S. Supreme Court ruled in Prince, as Ann told us this morning, that the right to practice religion freely does not include the right to expose the community or child to communicable disease or the latter to ill health or death. Parents may be free to become martyrs themselves, but they are not free in identical circumstances to make martyrs of their children before they have reached the age of full and legal discretion and can make that choice for themselves. So why do we still have religious exemptions from child health laws today? Hasn't the U.S. Supreme Court settled the issue long ago? No, unfortunately not. While the U.S. Supreme Court and many other American courts have ruled that parents do not have a constitutional right to abuse or neglect children as a religious practice, the federal courts have not yet ruled on whether states may enact religious exemptions from child health laws, giving parents not a constitutional right but a statutory right to deprive their children of necessities on religious grounds. We believe that religious exemptions discriminate against a class of children, depriving them of protections that the state extends to others. We believe these religious exemptions are unconstitutional because the 14th Amendment guarantees to everyone born or naturalized in the United States the equal protection of the laws. We do not know a way, however, to get a fact situation before the court that would force the court to rule on this constitutional question. Children cannot bring suits on their own initiative. Parents have to give permission for a child to sue, and the religious exemptions were created as a privilege for these very parents whose children are being discriminated against or deprived of protection by the laws. If a child is seriously ill, the state can seek a court order for medical treatment over the religious objections of parents, as Ann has described. And the court can issue this order without ruling on the constitutionality of a religious exemption. And courts will always avoid ruling a law unconstitutional if they can. And so, while we have seen women, racial minorities, the LGBT community winning more rights in the courts, we have not seen constitutional rights of children affirmed. It is rather startling to think how few constitutional rights children actually have. In the tragic case of Joshua Deshaney in Wisconsin, the U.S. Supreme Court ruled that the child did not have a constitutional right to equal protection from abuse. The U.S. Supreme Court said the Constitution is a charter of negative rather than positive liberties. The Constitution protects citizens from their government. It does not protect them from each other. It limits the state's power to act, but is not a guarantee of certain minimal levels of safety and security. More than 100 countries have federal constitutions with a provision that gives children some rights. One of our honorary members, Judge Charlie Guild in Connecticut, has led an effort to have a constitutional amendment in the United States giving rights to children. Also, if the United States were to ratify the UN Convention on the Rights of the Child, children would have a right to medical care. But neither the amendment nor ratification of the United Nations Convention has happened, and I do not see a way to get rid of religious exemptions from child health laws through the courts, and that is why, at 70 years old, I am still trudging from state to state, trying to persuade legislators to repeal these laws. Having laws that require all parents to provide medical care at the same threshold of seriousness of an illness or injury sends a message that society values the life of every child. And we firmly believe that having laws that just simply require all parents to provide necessities of life at the same threshold of seriousness are the fairest and the most protective of children, and we believe those laws will save lives. I would like to close with something that's not on the criminal law, but is something important to me. While I have a captive audience, I'd like to beg you to write to your congressman, your United States congressman and U.S. senators to oppose H.R. 1814 and S.862. H.R. 1814 is in the United States House and S.862 in the Senate. They exempt a person from purchasing health insurance if the individual's sincerely held religious beliefs would cause the individual to object to medical health care that would be covered under such coverage. The fact is, unfortunately, that the Amish got a religious exemption from buying health insurance under Obamacare, the Affordable Care Act. So now the Christian Scientists want one too. And that will be much broader because everybody, anybody could claim they had sincerely held religious beliefs against medical care, and I don't want to pay $600 a year for health insurance. It really would help children, it would help the children in the Followers of Christ and the Church of the Firstborn and the Christian Science Church if their parents were forced to buy health insurance. The U.S. Supreme Court has ruled that the Affordable Care Act is really a form of taxation. And although these groups say, well, why should I have to pay for health insurance if I'm never going to use it, and it doesn't pay for Christian Science treatments, and so why should I have to buy this product? Well, we all have to pay taxes for things we don't agree with. And for the Affordable Care Act to work, we have to have pretty much everybody in the system. It's going to be hard because there are many legislators that would like to destroy the Affordable Care Act, and the more people they can get to opt out of the system, the harder it will be to keep the rates low and make it work. So, and boy, in the House, the bill has 169 co-sponsors. So I really need your help, and I'd be very grateful if you would give a case for requiring these people to buy health insurance for their children. Thank you very much.